Okay, everyone, thank you for joining. We're going to get started now because these are short and sharp presentations. We don't want to lose too much time at the front end. Look, thanks for joining. As you will know, these are our IP in Focus webinars running over today and tomorrow. We've got 4 webinars. If you are attending this one but not sure about the others, please do jump on to the website, the wrays.com.au website. There's information there regarding the other webinars that we'll be running a little later this morning and also tomorrow morning. So please do have a look at those. The other webinars are covering off on topics such as commercial agreements, IP strategy and management, and patents. So there's, as they say in the classics, something there for everyone, but we'd encourage you to get involved and have a look at those. Look, wanted to mention early on in this presentation that we're not using the chat functionality. We will be using the Q&A functionality. So if you do have questions that come up during the presentation, please use that Q&A box and we'll address those in some time provided at the end of the presentation. So you can post the questions as we go, but we will address them at the end. Now, by way of introduction, my name is Peter Caporn. I'm a principal at Wrays Intellectual Property. I work in the patent chemical group, but am a patent and trademark attorney with about 30 years experience, having started with a patent attorney firm straight out of university way back in 1989. So I do know the innovation environment in Australia quite well and have lots of experience working with clients both in patent and trademark matters over that time. Okay, well, hopefully all the technology runs as it should, and I'm about to click a button which will get us going into our webinar. But as you can see, this is all about trademarks and why they matter. And the tagline there is, who are you and how are you perceived, is really what we're looking at there in terms of your trade out there in the marketplace. Rightio, very briefly, Wrays I've mentioned, and we are this year, having been established in 1920, now turning 100 years old. So that's quite a milestone for us here at Wrays. And you'll note there that over time we've expanded the Wrays practice to include legal and IP management, and we are today one of the largest independent intellectual property firms in Australia. Great place to start is, what is intellectual property? We need to be on the same page in respect of what intellectual property is if we can actually tackle this subject sensibly. And look, there are many different definitions. I've seen quite a number over the years. This is useful and pretty, as you can see, but look, IP is really a tangible representation of the intellect and creativity. It is the substance of creative endeavour, the property of your mind or your intellect. And as we often feel able to grasp it, we see it in terms of intellectual activity in the industrial, scientific, literary or artistic fields. Now that's all very academic sounding, but if you do think about it, it does make sense and will make more sense as we move through the presentation today. Why is IP important? Look, I think these days, compared perhaps to 20 or 30 years ago, people do have a better handle on why intellectual property is important, but it's worth touching base on again. It helps us maintain a competitive marketing advantage, or as you know, 10, 15 years ago, it was all about sustainable competitive advantage, but that's what we can wrap up in our IP. It can help us secure investment. We see that a lot where if people are listing or if people are simply seeking private investment, those investors want to know that the intellectual property has been looked after and captured, identified as well, as you'll see in the webinar relating to IP management. Arguably, intellectual property helps consumers make better choices. It ensures that products and services are authentic, so you are getting what you pay for, in a sense. It rewards and incentivizes innovators for their creativity and facilitates the free flow of information, and really drives and spurs further innovation. This is a slide that I've borrowed from the Visual Capitalist website, and they've in turn borrowed it from Aon. What you're seeing here is a visual representation of the increase over time of the value of intangible assets relative to tangible assets. Tangible assets are the bricks and mortar. They're easy to value, they're insurable, and they're what historically companies and individuals have felt comfortable with. Whereas that, you know, creative product of the mind hasn't been quite so easy to get a handle on. But as you can see, there's quite a significant difference there between the attributed value to intangible assets from 1975 through to 2018. And if I just move these boxes, I can recite the actual figures. So in just 45 years, the intangibles have evolved from a supporting asset into a major consideration for investors, and they make up 84% of all the enterprise value on the Standard & Poor's 500, a massive increase, which went from 17% in 75 up to 80%, or well, over 80%, as we've heard. What are the common attributes of intellectual property? And I won't spend too long on this because we need to get on to trademarks, I understand. Look, they're territorial in nature. They provide a right to exclude others from doing something. Typically, the scope of the monopoly is determined by reference to what has gone before or to prior art. There are remedies provided in terms of intellectual property infringement, as you can see there. And they typically will have a finite term, although importantly, in respect of the trademark protection that we're talking about today largely, that can be without term. You may need to renew it, but you can keep it going forever, dare I say it, if you choose to do so. So many of the trademarks that we're familiar with and comfortable with today, you know, are 100, 150 years old. I think, for example, Qantas is also turning 100 this year along with Wrays, and what a year to turn 100, of course. But anyway, we will get a chance to celebrate that in the usual way a bit later in the year. We're very hopeful. The types of IP rights broadly: patents protects how it works, how it does what it does. Trademarks, what is it? How is it known? How are you familiar with it? And design protects visual appearance. Copyright, the expression of an idea. And confidential information, anything that you choose to try and keep secret and not put into the public domain. They each have their own protection regimes or manners in which they are protected. The first three of those, patents, trademarks, designs, are registrable rights. Copyright and confidential information exist, registered or otherwise. Some countries allow copyright registration. Okay, on to trademarks, our key topic today. And look, very generally, a trademark is a sign that's used to distinguish goods or services provided in the course of trade by a person. So what distinguishes your goods or services from those of other people trading in that same space? There's a wide range of things that can function as trademarks now. This list has expanded over the years, but very well known, of course, letters, words, names, numerals, devices. And when we talk about devices, we're talking about logos. More broadly, we talk about brand. Now, of course, brand is a much broader thing than simply a registered trademark. But again, we'll look at that in a little bit more detail shortly. But interestingly, over the last 20 years or so, it's been introduced the fact that you can have aspects of packaging, shape, color, sound, or sense that also function and may be registered as trademarks. Now, not surprisingly, a trademark, if it's going to identify you in the marketplace to a potential customer or a real customer, must be capable of distinguishing the goods or services that you offer from those that are dealt with or provided by other traders in that same space or your competitors. So there are certain types of words, certain types of images and shapes and sounds and scents that won't be registrable because they don't distinguish, but we'll get onto that in a minute. And look, it's a good rule to acknowledge that every business has a trademark, whether they realize that or not. But not every business has a registered trademark. And as we'll see, registered trademarks provide a variety of advantages over simply unregistered marks. So very quick examples. And we've given away the answers there. We can do this in question and answer form, walking our way through it, but I felt that just for expedience, we'd whip through this quickly. But these are examples of some well-known trademarks. So for example, which company sells its chocolate in purple wrappers? Of course, that's Cadbury, as you'll see there. We've probably all been a little too familiar with some of these over the isolation and lockdown that we've all been putting up with. Which company's barbecues are kettles on 3 legs? That's going to be the Weber barbecue. And which company's hardware stores are green, red, and white? Again, something we may have been doing too much of or not enough of, depending on who you are, like me, over the isolation period. But again, we all know what we're dealing with when we see a large box hardware store that is in those colours. We don't need to read the words Bunnings Warehouse. We can tell simply by that colour combination. More examples of well-known trademarks, all of slightly different forms and types, but BMW we're familiar with. There's 2 marks there, quite clearly, the BMW, but also the visual appearance of the device or the logo that we can see there. Then the Coca-Cola logo, the Intel logo, Apple's Think Different mark, again, a number of marks there. The actual Apple silhouette is a mark, the Think Different is a mark, the combination is a mark. Then we see the Coca-Cola ribbon. That is also a separately registered trademark. So typically traders will break their marks down into their component parts, and if you are able to, you will get the best protection by registering those separately, but also in a combination or a composite mark. The wool mark, you can see there, that's a certification mark. It's it's allowed to be used by traders that meet certain certification standards. So a certification mark is a subset of trademark. The Toblerone packaging that you can see at bottom left, that's an example of a shape mark. The triangular elongate packaging is unique to them and registered as a mark in Australia and a number of other countries. And then at the bottom right, you see one of the sound marks that are registered, the McCain ping, you've done it again. That is a registered trademark to McCain, or whoever owns McCain at the moment, I can't recall. So trademarks provide an enforceable statutory right that applies throughout Australia and is definitely superior to relying on what are called common law rights. It provides a public record of your rights and deters adoption by others. So if other traders who are looking to adopt a mark can go to the register and see that you already have that mark or a mark that is quite similar to a mark that they were interested in, they're less likely to adopt that mark. So it keeps your defined space in the marketplace clear. It raises brand awareness, and something that's quite significant is the idea of brand extension. So if McDonald's is going to launch a new product, of course it's going to be far more successful if they call it a McSomething than if they just called it a something. So it's this idea of allowing brand extension to trade off the reputation and understanding that they already have in the marketplace from the core mark. It allows you to generate income, perhaps through franchising, licensing, and gives investors confidence that the business is protected, as we touched on earlier. It indicates the source of your goods and services. We've covered that already. Protects the reputation that you've established. And just out of interest, registered trademarks are registered across 45 different types of goods and services. You register a mark in respect of the goods or the services, or both, that you are looking to trade in. And it's important there because you can have similar marks registered, but in respect of quite distinct areas of goods or services. Now, to be registrable, a mark must be capable of distinguishing your goods or services, and it must not be similar to the mark of another trader who might be using or registering their or have registered their mark for similar goods or services. Here's an example of a good mark versus a not so good mark. Abacus for computers or for computer retail. Look, it's illusory at worst, but quite registrable and is registered in respect of computers and computer retail. If you look at the mark on the right-hand side, the outdoor furniture specialists, taken alone, the outdoor furniture specialist is directly descriptive of what they are doing and is not a great mark. However, in combination with the logo that you can see on the right-hand side there, that is ultimately a registrable mark, but again, not a strong mark because the words in and of itself are not registrable. I want to run through some very quick examples of marks that are perhaps perceived either to be distinctive or not. Darwin Funeral Services, and these are all taken from very recent examples in the last 12 to 18 months where people have attempted to register certain marks. Darwin Funeral Services, it is not distinctive of funeral services provided in Darwin, quite obviously. Now T2 was sought to be registered in respect of timber products. And yes, well, T is for timber, but the mark itself is quite distinctive, so it was registrable. Think Different, we've already seen that in terms of Apple Inc., and that is considered to be distinctive because it's not directly descriptive of the nature or the nature of the goods or their character of the goods. Finger tape, not registrable in respect of band-aids or plasters, should I say, without misusing a trademark. Some more examples of whether marks were considered similar or not. Census was considered to be too similar to Censes direct or Censes data in respect of advertising and so on. Aqua Smiles and Aqua Dental were considered to be too similar to allow both to be registered. And that final example there, Aldi tried to stop Albi being registered. Albi, of course, in respect of beers, Aldi had to have a registration that covers beers, but even the word Albi versus Aldi, they were considered to be sufficiently different to allow both to be registered. An example from the last week or so, Seek, the jobs classified provider, I guess. They marry people up with new jobs. Their registered marks there you can see on the left, and Seek Visa is a law firm that offers immigration services, and Seek are interestingly looking to prevent Seek Visa from being able to operate under those marks. And so in the next 6 to 12 months, we'll see how that plays out. I need to keep moving, but we're not too far off track. So how do you go about getting a trademark registration in Australia? Well, of course, you start there at top left, choosing your mark, and you identify the goods or services that you need to get registration in respect of. And it is always best at a first instance to conduct some clearance searching to make sure that mark is actually available for you to use, because you don't want to put a lot of time and effort into a trademark if you're going to find out 6, 12 months, 24 months, 36 months down the track that that investment has been for naught because someone who had a pre-existing right comes along and asks you to stop doing what you're doing, and worse still, to deliver up all the goods that are marked with the trademark. Once you apply for your trademark, examination will occur. Depending on how quickly the Trademarks Office can get to it, you can speed that process up by a number of mechanisms if appropriate. And hopefully at the end of the examination process, where the Trademarks Office will compare your mark with pre-existing marks, and they'll also make a determination about whether it's the type of mark that can be registered. Good chairs won't get registered in respect of chairs, whereas, I don't know, Cyclops chairs might be registered in respect of chairs. It certainly stands a much better chance because it's not directly descriptive. After acceptance, there's an opposition window in which a third party can choose to oppose the registration of that mark if they believe they have an interest in that mark not being registered. And there's a variety of grounds on which they might be able to do that. Most commonly, it will be either they don't actually think the mark is registrable, it's not distinctive, or they might feel that they have a pre-existing right that they want to defend. And after that, you get registration, and registration lasts for 10 years and can be renewed in 10-year periods ad infinitum beyond that. When you're using your trademark, how should you use it? Well, you should make it clear that it is a trademark. If it's a registered mark, then you will often see, as appears at left there, my mark with the little R in a circle. You often will see my mark with the TM superscript. Often the my mark with the R and the my mark with the TM are used interchangeably. Typically, you shouldn't use the R superscript if your mark isn't actually registered, and there are penalties for that. At the very least, you should make your mark stand out from what is around it. And as you can see there, we've capitalized it. So that's at the very least. If you've applied for your mark, it's not registered yet, then just use the TM. You are allowed to use the TM even if you haven't applied for it. If you believe that a thing is your mark, then you are entitled to put TM next to it to indicate that you believe that to be your distinguishing feature. A few quick misconceptions about trademarks. I've got a business name, or I've got a company name, and therefore I have a trademark. That's simply not true, and has led over the years to all sorts of consternation amongst clients. But it's one key thing you must remember. Just because you have your business name or company name registered doesn't mean you have a registered trademark. Misconception number 2, that if I get my Australian trademark registration, therefore I have the world protected. That's not the case. There are mechanisms that you must go through if you want to obtain overseas trademark protection. I'm rushing through these a little bit now, but rest assured the presentations will be available to you at some point fairly soon. Third misconception, domain names. Again, much like company names. Oh, I've got the domain name and therefore I have a registered mark, or I own the mark. That's not the case. I bought the name, therefore I'm not infringing somebody else's trademark. That is also not necessarily true. And it's interesting to note that you can infringe a registered trademark simply by registering and using an identical or similar sounding domain name. There are cases decided on that point in the last 12 to 18 months. So you must be careful in that regard and seek advice before jumping into this. The key takeaways from this: always consider whether you should be registering your mark. Unregistered or common law rights are actually difficult and expensive, time-consuming to enforce. As I've noted, a business name gives no protection in and of itself. You should search first and then use or file. File in the right name. If you get that wrong, it can be fatal to your trademark. So that's very important to discuss with your advisor. Registration is relatively expensive in the grand scheme of things, particularly compared to what might come from damages for infringement, the need to rebrand, the cost of litigation. And my old fave is Grumpy Cat. And would you be grumpy if someone else used your name or logo in respect of the same or similar goods or services? If you would be, as Grumpy Cat is, 100% unimpressed, then you should at least be talking to your advisor about whether you can or should be registering your own marks. Now, I do hope that wasn't too much of a rush from about the midpoint through to the end. Sorry about that. 30 minutes is not a lot of time, as I've found out. Now, I'm just going to check on the Q&A. We do have a couple of questions. What is the difference between a service mark and a trademark? Yeah, look, that's an interesting one. We don't tend to use the term service mark so much in Australia, but certainly in the US and potentially in Europe, they do refer to service marks. That simply means a registered trademark, but that is registered in respect of services rather than being registered in respect of goods. So they're all registered trademarks, but it's simply in respect of the services that are offered. So for example, in the Bunnings example that I gave earlier, they have a service mark in respect of the retail and wholesale of hardware items through a retail premise. That's a service mark. Whereas Makita is a mark that might be on a power tool, and that's in some countries referred to as a trademark as opposed to a service mark for services. Okay, just looking at another question. Yes, this is around what's the most appropriate indication to use when you have applied for a trademark registration, but it's not registered yet. And at that point, we would recommend that you use the TM superscript. You can't strictly start using the R in a circle superscript at that point, but it's more than appropriate to use the TM superscript at that time. Well, look, thank you very much. There are no further questions at this point, and I've gone 1 minute over time already. So look, for the sake of keeping these short and sharp, I want to thank you for your attendance today. We're always happy to get in front of our clients and potential clients, even at these rather unusual times. As you can see, I'm at home and doing this from the relative safety of my study at home. Look, we're more than happy to engage with you at any time around matters of trademarks or other intellectual property matters at your convenience. We're on the phone, we're contactable via email and on the website. As I mentioned before, we will be having 3 more webinars. The details are available on the website around those. We've been distributing that also on LinkedIn, so keep your eyes open there. Look, we're very pleased to have been of service today, and I look forward to seeing you all in person at some time in the very near future. So thank you very much.